Decision podcasts by the New York Prosecutors Training Institute are made possible by Resemble AI. Convert your text to voice at resemble.ai. Find this and other decisions at NYPTI Law. www.nypti.org/law.
People v. Zave R. Bacon, decided June 18, 2025. Memorandum. The order of the Appellate Division should be affirmed. Defendant failed to preserve his claim that his constitutional right to confront the witnesses against him at trial was violated. At defendant's trial for robbery and assault of two victims, the prosecution called two police officers who testified about statements made by the victims at the scene of the crime. As relevant here, the officers testified about the identities and physical descriptions of the assailants provided by one of the victims while she was in an ambulance being treated for her injuries. Defendant's only contemporaneous objection to this testimony raised a sustained, double hearsay objection when an officer related statements made by one victim to the other. Although the victims were expected to testify at trial, neither did. At the close of the people's case, defendant moved for a trial order of dismissal based on insufficient proof. Counsel argued that since we do not have the complainants, the jury is left with a wrong impression as to the physical and mental condition of the female victim at the time of the incident. There was no ability to cross-examine or even on direct examination for the jury to understand that she had taken her usual dose of methadone. The court responded by asking whether the question before the court is, based upon the evidence that they did put in, whether it was lousy or not lousy or whatever it was, is it sufficient to go forward? Defense counsel confirmed the court's understanding and explicitly noted the standard applicable to claims of legal insufficiency. Under CPL 470.05, a question of law is preserved for appellate review where a protest to the alleged error is raised in the trial court at a time when the court had an opportunity to correct it, or where the court expressly decides the question raised on appeal in response to a party's protest. Defendant did not raise the constitutional challenge he now presses before this court, nor did the court rule on the constitutional question, see People v. Cabrera. Defendant's motion at the close of the people's case did not invoke the Confrontation Clause, and the colloquy that took place between defense counsel and the court makes clear that the motion to dismiss was neither intended nor understood to raise a constitutional issue. Moreover, counsel did not invoke or rely on any case law dealing with constitutional protections. Instead, counsel made evidentiary arguments regarding the persuasive quality of the prosecution's proof and, when asked by the court, confirmed that the motion was limited to the sufficiency of the evidence. Further, the timing of defendant's motion at the close of the people's case, which defense counsel specifically referred to as a trial order of dismissal, see CPL 290.10, providing that such motions shall be directed to the sufficiency of the evidence, suggests that defendant's aim was not to challenge testimony of the victim's statements as violative of his right to confrontation, but simply as failing to meet the evidentiary bar for a prima facie case, cf. People v. Garcia. Additionally, counsel repeatedly told the court that his motion was focused on the third-degree robbery charge, demonstrating that the argument was a legal insufficiency one, rather than a Confrontation Clause challenge, which would necessarily apply to all charges with equal force. Contrary to defendant's argument, the mere reference to a lack of cross-examination was insufficient to alert the court that defendant was making a constitutional argument, see People v. Kello. We have reviewed defendant's remaining arguments and find them to be without merit. Order affirmed, in a memorandum. Judges Garcia, Singas, Canataro and Halligan concur. Judge Rivera dissents in an opinion, in which Chief Judge Wilson and Judge Troutman concur. Decided June 18, 2025.
Decision podcasts by the New York Prosecutors Training Institute are made possible by Resemble AI. Convert your text to voice at resemble.ai. Find this and other decisions at NYPTI Law. www.nypti.org/law.